Hello, my name is Doug Pinkham. I'm the senior attorney here at Pinkham and Associates, a dedicated family law firm here in Orange County, California. I'm going to talk in detail about the Form FL 300. It's called the request for order. That is the form that you fill out, file, and serve on the other party when you're asking the court to make orders such as child custody, child visitation, child support, spousal support, those kinds of things. Frankly, if you're asking the court to make orders on anything, you're going to need this form. Okay, let's start at the top. Hopefully you have an FL 300 in front of you and you can follow along or fill it out as we go along. If you're trying to fill out your FL 300 as we go along, just pause the video when you need to and come back to it when I move on to a different section. Okay, on page 1 at the top, you're going to put your information. Then underneath that, the court's information. You can get that court's address online without question. Then you're going to list the petitioner's name, then the respondent's name underneath that. Then, in the box that is entitled Request for Orders, you're going to mark the boxes that apply to what you're asking for. Child custody, child support, attorney's fees and costs, modification if you're modifying an existing order for custody, visitation, or support. Then visitation, spousal support, temporary emergency court orders, or other. And other is very important, actually. If you're asking for something that's not specified in one of those previous boxes, then mark other and write underneath it in very short, you don't have much room there, so in just a couple of words what it is that you're asking for. You're going to be able to expand on that in a different section of the form. Okay, so right below that, where it says to and then name in parentheses, you're going to put the other party's name there. Then you're going to, don't worry about the box that has date, time, department, and room in it. The court is going to write that information in there when you file this form with the court. Okay, and then number 3, attachments to be served with this document. If you're asking for any financial orders, child support, spousal support, attorney's fees and costs, any financial orders at all, you're going to need to fill out an FL 150. It's an income and expense declaration, and attach this to the form. You're also going to need to attach to this form, when you serve it on the other party, a blank income and expense declaration. Then you're going to put the date below that, write your name on the left, and sign your name on the right. Don't worry about the information below the words court order. The court will fill that out later. On page 2, at the very top, you're going to again put the petitioner's name and the respondent's name, and also the case number off to the right there. The case number also goes on the front page in the box that is entitled Case Number. Okay, then we start underneath where it reads Request for Orders and Supporting Declaration. Mark the box either petitioner or respondent, whichever party you are. Then go to number 1. If you're asking for child custody orders, mark that box. Just put a check mark or an X is fine. Then you're going to write the child's name and age right underneath that under A, 1A. Next to B, you're going to mark that box if you're asking the court to make legal custody orders pending the hearing. Your hearing might not be heard for up to 2 months. And if there's a continuance, it could go 3 or 4 months. So if you want orders pending before that or during that time, you'd want to make those, put that information in there. For example, you'd simply put, under B, you'd mark to be pending the hearing, and underneath the legal custody, you'd put your name in there. If you want to have legal custody before the hearing. Physical custody off to the right where it says C, again, you'd want to put your name under there. D is a very handy section. If you mark that box, you can attach forms such as the child custody and visitation application request for child abduction prevention orders. It's a form FL312 if you think there's a chance that the other parent will take the child outside the country. If you're asking for holiday orders for holiday visitation, you can use an FL341C to do that, and you'd mark that box. There's other forms and boxes to mark there. Mark what you're going to attach. You don't mark a box if you're not going to attach the form. If there are existing child custody orders, you need to mark E where it says modify existing orders. You must put the date that that order went into place, when that order was filed, and where it says ordering, specify, put what the order is. So you're going to want to specify what the custody orders are. Joint legal, joint physical, sole legal to dad, and joint physical to both parents. Whatever it is, you're going to want to list what the court orders are now for legal and physical custody. Then the next section, child visitation, under 2. If you want the court to make orders on child visitation, mark that box. Again, you are going to want to, you must mark the box with modify existing orders if there are existing orders in place now. Again, you need to put the date that those orders went into place and what that order specifies. If you need more room for any of these sections, and this is one of those sections where you may need more room to clarify exactly what the physical custody and visitation orders are, then you can always use an attachment form. If you use an attachment form to complete some of these sections, under this particular section, mark 2, child visitation attachment, and then write what you need to underneath that. If there are present domestic violence orders in place, either for you or against you, you must mark box number C and put the information below that of the court that issued the restraining orders. Number 3, child support. Again, if you're asking for child support, you're going to need an income and expense declaration to be filed with this, and you're going to need to serve a blank income and expense declaration along with your completed income and expense declaration on the other side. But if you're asking for child support orders, mark that box. Then you're going to put the child's name and age below that, and mark the box B. I request support based on child support guidelines. All you need to do is mark that box if you're just asking the court to make guideline support orders, which are probably 95% of the child support orders in place. Then you don't even have to put a number under C where you're asking for the amount. If there are present child support orders in place, you need to mark box number D, and again you need to put when that order went into effect and what that order is for. So if an order went into effect January 31st, 2015, you'd want to put January 31st, 2015 there and what it was ordering. If it ordered $1,126 a month in child support, you'd want to put $1,126 a month right there. Number 4, spousal support or partner support. If you're asking for spousal or partner support, you're going to mark that box. Again, you're going to mark the box under A, the amount requested. And I would recommend, this is such a technical area, but there are child support calculators online. They also give a number for spousal support. Now, you need to understand that is not how the court figures out long-term or permanent spousal support. In fact, the court is not allowed to use DISO-master or ex-spouse or any other child support calculator to figure out spousal support for long-term spousal support. But if you use those calculators, it will kick out a number for spousal support, and you can get an idea of what you might be entitled to. And you can put that number or an amount near that number in that box. If there's some reason why you need an extreme amount of spousal support, medical concerns, medical care, whatever that concern may be, then you can put a higher number in there. It does not necessarily mean that that's what you're going to get, but you can ask for whatever you want to ask for. If you are the payor of spousal support and you want to terminate the existing order, you're going to mark box B. And again, you need to put in the date and what that order was about right below that. If you are the receiver of spousal support and you want to modify that spousal support order, you're going to mark box C. And again, you're going to put the order information underneath that. Okay, so there are a number of forms that can assist you in these requests. There's a specific form, FL 157, that specifies requests for spousal support and partner support. If you want to use that form, that'll benefit you. One, it's easier to fill out. Two, it's got most of the information that you could possibly need to put in there. And three, and we'll get to this at the end, but it does not count to the page limit that you're allowed to file and serve when you make these kinds of requests. There's a 10-page limit. We'll get into that detail. But any of those forms don't count to that page limit. And again, right there under E, it says an income and expense declaration, FL 150, is required to be filed with this. And you're going to need to do that. Number 5, if you're asking the court to order the other party to pay for your attorney's fees, mark that box. Again, there are other forms that it lists that you may need to file. Financial orders, you're going to need that FL 150. And you also will need to fill out an FL 319, which is a request for attorney's fees. And again, that form will not count toward the form limit, the page limit. Okay, number 6 is property restraint. If you are making a request that the other party be restrained from transferring, encumbering, hypothecating, canceling any insurance policies because you think that might happen, you might want to mark that box. There's another box here for notification of any extraordinary expenses that might affect the other party. If you want notice of any notice, if you want notice of the other side making any extraordinary expenditures that will affect you, mark that box. If you want the other party to be restrained from selling or transferring any personal property that might affect you, you're going to mark those boxes. And of course, there's a box there to limit the other side from taking out any loans or any liens that would affect you. Then you're going to want to mark C. Okay, number 7. Oh, one specific note with that. Those particular restraints are also part of every divorce and legal separation filing. We call them ATROs, Automatic Temporary Restraining Orders. They can be found on the back of the divorce summons or the family law summons. Check those out. Those go into effect automatically after the divorce or legal separation is filed and served upon the other party. Number 7 is property control. You can ask the court for exclusive orders for control over certain property. Say you want exclusive use of the house or the apartment that you both live in. You can ask for that here. If you want exclusive use of the car that you normally drive, because you have a fear that the other party is going to come and take the car from you, you can ask for it here. If you want exclusive control and care of a pet, you can name that pet and ask for that in this order. If you want exclusive control over a business, you can ask for it here. But I can tell you this, if you're asking for exclusive control over a business, you're going to need a lot of detail. Who runs it, how it runs, what kind of business, what's going on, and specifically why you should have control over that. You're going to need to be detailed. That's going to go under the section where the declaration's at on the back. We'll get to that. Okay, number 8 is, number 7B. If you Also, on number 7, property control, B, if you mark B, you will mark B if you are asking the court to make the other party make certain payments. Continue making a house payment, continue making the rent payment, continue making the car payment, or insurance payments. That's where you would want to list that. That's particularly important if one party is not employed and is a stay-at-home parent and wants the other party to continue paying for the necessities of life. That is the box that you would want marked. Number 8, other relief. This is the box that you're going to put if the requests you're making or if additional requests that you're making of the court don't fit into one of those previous categories. For example, you could be asking the court to force the other side to obtain an insurance policy of some kind, or open and inspect maybe the other party's safe deposit box because you believe that there are valuables in there that they may be hiding. You may be asking for an order for the other party to cooperate in the sale of a business or cooperate in the sale of a home. It's very common to have serious difficulties getting both parties interested in selling the home, keeping it clean, keeping the yard kempt, a pool clean. If the party remaining in the house doesn't want to sell, doesn't want to move, they might not be cooperating in the sale of the house. So you can get those orders by marking this box and specifying what it is that you want. Number 9 on the back. This is a request that you would mark and put a number in there for the amount of days if you think it's going to be difficult to serve the other party, or if you're asking the court to hear this order, request for order sooner than the normal time span, which might take 6 weeks, 8 weeks. You would want to put a number in there so that the other party can be served in fewer days before the hearing, less notice, to give them less notice. You have to get a special order to be allowed to do that. Number 10, now this is very, very important. It says facts in support of orders requested, blah, blah, blah. Underneath 10 is exactly where you're going to put your declaration. It's basically a story to the judge telling the court exactly what you want, why you want it, why you should get those orders, why it makes sense for the court to order make those orders, and you might also want to add in there what potential detriment may come if the court does not make those particular orders. Of course, you don't want to make it sound like a threat, Your Honor. If you don't make these orders, then the world's going to fall. But you need to put that that information in there if there's some information that the judge needs. Very important. It also mentions in there the 10-page limit that I previously mentioned. Your declaration is limited to 10 pages. The very interesting thing about that, though, is all of the forms that you attach to this request do not count toward that 10-page limit. So, for example, if you are going to ask for orders for holiday visitation, who gets the child for Christmas, what that's going to entail, who gets Easter, who gets Thanksgiving, who gets 4th of July, an odd numbered years, even numbered years, whatever. That's a form number FL 341C, and if you attach that form, it requests a ton of information, a bunch of different orders, yet does not count toward the 10-page limit. So that's the kind of thing you want to think about. Also, very importantly, there's a balancing here that you want to take into account. One, if you make your declaration 9.9 pages long, you're going to bore the judge before they get to the 10th page. So you want to make it as short as possible, but you need to weigh that with the fact that if you don't put what you want or the reasons you want it in your declaration, the judge isn't going to know. So if you think there's something important the judge should know, you must write it. If you want the court to know it, you got to write it in the declaration. Just try to be succinct about it, because you don't want to turn in a 10-page declaration along with 4 or 5 additional attached forms. That's an awful lot of information for relatively simple orders most of the time. Okay, then you're going to put your name on the bottom, date it, and sign it. Now keep in mind, if you notice the form right above the word date, it says, I declare under penalty of perjury under the laws of the state of California that the foregoing is true and correct. Everything you write in here is under the penalty of perjury. So it better be correct. It better be right. Also, if you attach any forms, the information on those forms are going to be incorporated into this, and the information on those forms better be correct. You are likely to have more questions. If you do, you're more than welcome to give me a call. I always provide free initial consultations. Again, my name is Doug Pinkham, and the phone number here at the firm is 714-730-0111.